Good afternoon, everyone. We are here in DN 20-2020, and it's my understanding that there has been counsel appointed to all of the parents and that a pre-hearing conference was conducted this morning. So why don't we go ahead and start with all counsel introducing themselves and their client, please. Let's start with Ms. Jones, the mother of the children, please.
Brooke Barker Taylor, Your Honor, on behalf of Child and Family, or on behalf of Molly Jones, the mother of the children.
Okay. All right, and on behalf of Alan Rial.
Judge Jim Reitzman of the Conflict Defender's Office, representing the father, Alan Rial.
Okay, and on behalf of the Guardian Ad Litem's office.
I'm Heather Sather. I'm the guardian ad litem for the two children.
Okay, who is here on behalf of the state, please?
Your Honor, Scott Peterson here on behalf of the state with Heather Eliezer, Child Protection Specialist.
All right, well, thank you, everyone. Mr. Peterson, based on your review of the information in your office, do you have any reason to know or any belief that the two children in this case are Indian children?
Your Honor, the department doesn't have any indication that these children are Indian children for purposes of the Indian Child Welfare Act.
How about counsel for Ms. Jones? Any information at this point that the children, either of them, are Indian children?
I do not have any information suggesting that the children are Indian children. I've also had an opportunity to speak with my client about that, and Ms. Jones also does not have reason to believe the children are Indian children.
Thank you. Counsel on behalf of Alan Rial, any information regarding whether either of the children are Indian children pursuant to ICWA?
I have the same position as mother's counsel, Your Honor. My client does not know of any Native American heritage.
Does the guardian ad litem disagree at all, Ms. Sather, with the statements of all counsel, or have any other information to indicate that either child could be an Indian child under ICWA?
No, Your Honor, I have no additional information in that regard.
Okay, so before we get started then, based on the information that counsel has just shared, I'm going to make the finding on the record that there's no evidence before the court that any participant knows or has reason to know that either child in this case qualifies as an Indian child. Therefore, ICWA does not apply to these proceedings moving forward. In the event that any party subsequently receives information that provides reason to know that either child is an Indian child pursuant to the ICWA, you are required to inform the court immediately, and then we can adjust our proceedings. But for now, we will proceed that this is a non-ICWA matter. So, Mom and Dad, what I want you two to understand is that the purpose of all of these people who are participating, and I appreciate everyone's participation by Zoom, is everyone is here to reunify your family, however that family looks. My job is to make sure that when your children come home, that it is a safe, stable, and sober environment so that we don't have to become involved in your lives again, and you have the tools and the capacity to be able to move forward with your family. To get there and to do that, there's going to be something called a treatment plan, which is what is used by the department. It's used in conjunction with your attorneys who you've met today, and it's used by me as a way to make sure that we take care of all of the issues and provide you with the services that are necessary to make sure that you can be the parent that I know you want to be. Part of that process is a pre-hearing conference. And it's my understanding, Mr. Peterson, that the parties engaged in a pre-hearing conference today.
Yes, Your Honor, we did.
Could you please give me an update as to how that conference went and any agreements that were made regarding any of the key issues such as parenting time, as well as placement of the children, and then the specific issues that were identified at this point that are barriers to returning the children?
Thank you, Judge. Both parents did attend the pre-hearing conference. Molly Jones, with her counsel, Brooke Barker Taylor, and Fred Reel with his counsel, Jim Reinsma. Molly Jones was personally served, but Mr. Reel has not yet been served. Ms. Jones reports that she believes that Mr. Reel is on the birth certificate, though they are not married. Judge, if that turns out not to be the case, we'll be seeking a DNA test to determine paternity. But for now, we believe that's unnecessary. Your Honor, we talked about where the kids are placed. They're placed in out-of-home care, in regular foster care, not with a relative. But we also did have Mr. Ron Jones, who was the grandfather of these children, participate in the pre-hearing. And Ron Jones expressed a willingness to be placement for the children, as well as potentially to move in with his daughter should the kids be returned to her care sometime. Mr. Jones reports he does have a DUI from a significant amount of time ago, 17 years or something. So it's likely that for him to be the placement, the state would need to waive its rules on that. So for right now, we don't believe it's possible to move the kids in with Mr. Jones. Your Honor.
Mr. Peterson, do the same regulations that give you pause about, from the department's perspective, about the old DUI, would they limit the grandfather's ability to be a safety resource in the home if the children were to return to the home with the mother?
Your Honor, I don't believe so. I think that makes it a different circumstance, but that's something that we'd have to investigate. If the department can satisfy themselves that he's able to work in that role, I'm not sure the regulations apply in the other way, but maybe Ms. Leeser could help me out with that.
Yes, it would be a different circumstance. So he'd be allowed to move into the home and help be a safety resource.
Okay, thank you. Mr. Peterson, were there any other family members or close family friends that were identified by either of the parents during the pre-hearing conference as potential placements for the children?
Your Honor, none identified. They didn't have any other potentials. Mr. Jones is married to Rita Jones, who's quite old, so she's not able to work in that same role. Judge, we realize that the presumption is that the parents should have unsupervised contact, but that is the issue with mother. As to father, he hasn't had no contact since removal. He does have an active warrant. We do have concerns about drug use. He did express that he would like to see his kids, though, as soon as possible, and so we'll make a referral to a child supervision agency, as well as Ms. Leeser has already made plans with him to have a supervised visit in her office. So hopefully that can happen today or tomorrow. Your Honor, the kids do have some special needs, or at least needs. The younger child, Alicia, is showing some delays, and so the department is going to get her evaluated through ECI for either special needs or just for some help to get her on track. The older child, Fred, has admitted to smoking marijuana. He's only 13 years old, so we want to get him evaluated to see if he has a drug issue and to get him treatment right away, obviously to nip that in the bud. Judge, we do have some concerns too about domestic violence, and so we'll be looking to get the kids in the home, to get the kids into counseling. Your Honor, we talked about potential treatment plan tasks as well, and these parents would both be asked to do CD evaluations of all the recommendations, and we want them both to be on testing. Molly Jones has already indicated she'd be willing to test, but has missed a few that the department has set up with her, so we need to get her squared away and on track there. We'd like to get Ms. Jones into counseling. She's got PTSD and would benefit from that. She had seen a counselor before, but had fallen away. We want mom to have a stable source of income or legal employment so that she's able to support herself in the event that her boyfriend can't move back in the home to help. We asked Mr. Reel to comply with his criminal issues. He's got an outstanding warrant, and there was a criminal issue from the time of removal. And Judge, eventually we'd like to get them to couples counseling to make sure that this home stays stable. Your Honor, I don't believe at this time there's an objection to the court continuing the EPS and maintaining the adjudication hearing that's set for late December. But Judge, we'd ask you to set a status hearing in the near term so that we can report back on whether or not Mr. Jones's distant criminal charge was something that the department could waive so that we could make him either be placement or easily be a safety resource to move the children back home. And that's it from the department's perspective.
Okay, thank you, Mr. Peterson. Ms. Barker-Taylor, on behalf of Molly Jones, the mother, any additional information you believe is important for this court to know based on the pre-hearing conference or your conversations with your client today?
Yes, Your Honor, thank you. As Mr. Peterson stated, Ms. Jones is not contesting the show cause relief today, although she doesn't specifically admit to the truth of any allegations contained in the petition or affidavit, Your Honor. Despite her agreement on that, I would like to address the court regarding placement of the children. Your Honor, I think it's important for the court to ask what specifically is safety issues exist to prevent the children from coming home today. And it seems to me, Your Honor, that based on our discussions in the pre-hearing conference, any safety issue that is a concern for the department can certainly be mitigated. And I think it's important for us to put our heads together. As you heard, Your Honor, these children are in stranger foster care, and we have at least 2 people who are willing and able to have the children. First, Your Honor, we agree that, the safety is paramount, and that's the most important thing. And in my discussions with Ms. Jones, she's absolutely willing to cooperate with the department in any way she needs to mitigate any safety concerns. With respect to the drug use, Your Honor, with respect to the drug testing, Ms. Jones does acknowledge that she missed a couple of appointments, but she certainly understands the importance going forward to not miss any of those. She's in a difficult position right now, Your Honor, and she was out getting job applications to secure employment. So with regular UAs, Your Honor, that certainly mitigates the concern of any drug use, as the department will get immediate notice if there is a positive test. Secondly, Your Honor, Mr. Peterson noted a concern about domestic violence and Mr. Real, and mother is absolutely willing to ensure that father does not come into the home and that any contact between Mr. Real and the children would go through the department. Additionally, Your Honor, I think there's a number of safety resources that could be utilized if the department were willing to agree to an in-home safety plan. We do have a third-party agency in the community who would be able to provide in-home services. So not only would they be acting as a safety resource, that agency could possibly also help with the issue of Alicia and helping mom take the appropriate steps forward to get assessed. And finally, Your Honor, the maternal grandfather, Ron Jones, is willing and available to not only be placement himself, but he's also willing to move into Ms. Jones's home to be a safety resource. Mr. Peterson mentioned the DUI. My understanding, Your Honor, is that this DUI conviction was more than 15 years ago. I think as a reasonable effort to get the children back into the home, it would be important for the department to seek the regional administrator's exception if that is in fact necessary, Your Honor. Your Honor, if the court is not willing to order that the children be returned home on an in-home safety plan, I would ask if the court would be willing to set this for a status hearing, but not 1 or 2 months down the road. Ms. Jones would like the court to reassess it in a week, Your Honor, a week to 10 days. And we're hopeful that that would give the department sufficient time to work with Ms. Jones on what they believe is needed. Thank you, Your Honor.
Ms. Berger Taylor, are there issues regarding your client's ability to get to testing as she's requesting UAs? Is she able to make the testing? We all know that that means she has to call a number every morning, and if her number's up, she's got to get there. Is that going to be a problem?
I don't think it will be a problem, Your Honor, but in the event it is, I know that Mr. Jones, the paternal grandmother, is willing to assist in providing that transportation.
All right, Mr. Reinsma, on behalf of Alan Rial, any update you'd like to give the court based on the pre-hearing conference?
Your Honor, unfortunately, I was not able to meet with Mr. Rial prior to the pre-hearing conference. He did show at the pre-hearing conference, though, and shared that he is no longer incarcerated. He is not staying at the family home. It is his desire to do whatever it takes to help the mother get the children back and to be placement. And to that degree, he is willing to stay away from the home during the pendency of these proceedings until it's otherwise approved by the department or yourself, of course. He understands that there's a warrant out for him, as is in the affidavit. I will be working with him to address that with the public defender's office and have him start working on those matters to make sure that's not a roadblock in this case. He has a strong relationship with his children. He would very much like to start visitation through the pre-hearing conference. It's my understanding that the department is going to oppose any kind of unsupervised visitation until he gets a CD evaluation and starts working on his criminal matters. And he is willing, of course, to work in whatever capacity he can to make those visits happening. He would agree with counsel for the mother that an in-home safety plan is probably the best avenue here. He thinks the mother is capable of taking these children in and addressing the department's concerns, as he was at the center of the controversy causing these things. And as long as he's out of the home, that should abate the department's fears. He has communicated some concerns about the grandfather, the maternal grandfather, having been involved in or having caused some trauma to the mother in this case, and is suspect of his ability to adequately have that grandfather supervise the visits, and more concerning, have him move into the home, as that may cause more trauma for the family. He thinks mom is capable of taking care of this by himself. Dad is couch surfing at the moment. He is going to find some stability in that regard, but he is willing to do whatever the department asks of him to resolve the case. He would like, at some point in time in the near future, to have visits. It's my understanding the department has said he can have visitations at the department with his children, but believes that it should expand further than that, as this is really not truly a serious issue that should have resulted in removal in the first place. Dad is reliant upon public transportation, does not have a vehicle in which to travel on his own. So he would prefer for drug testing to have the patch as opposed to UAs. He believes that is more conducive to his living situation at the moment. Again, he would very much like the children to return home under a safety plan, and believes that is the best outcome for this particular hearing. As he had not been adequately served, and he and I have not had an opportunity to have a thorough discussion on the matter, he would ask that the issue of show cause be continued out to the date and time set for adjudication.
Okay, thank you, Mr. Reinsma. Guardian ad litem, anything to add in addition to what we've heard from counsel for the parents and for the state regarding the pre-hearing conference?
Your Honor, I just would recommend that the birth mother participate in take a couple of UAs, so that prior to making a determination for an in-home safety plan. I think depending on what substances she may be positive for, that could impact what Ms. Eliezer would come up with in the safety plan. Also, this family is a family that's in need of services given the delay for the youngest child. The older child is exhibiting signs of being parentified and taking care of his little sister, as well as potential drug use by a 13-year-old. So part of the safety plan, when it is appropriate, and I do not believe the children should be out of their mother's care for much longer, I just would recommend that there be a series of in-home services to really assist mom in safely parenting and getting her children to the levels that they should be at. I have no objection to the continuance of the show cause to the time of the adjudication, and I think a status hearing within the month would be very appropriate in this case.
All right, well, Ms. Jones and Mr. Rial, what I want, again, both of you to understand is that all of this discussion is about how we get your kids back home with you and how we do that in the interim. And in order to do that, everyone's going to have some tasks that they're going to have to complete before the next time you have a hearing with me. And that includes the department. So for purposes of today, I'm going to continue emergency protective services. I'm going to continue the show cause until the date of adjudication. And I happen to have DN hearings in 13 days from now. And we are going to set a status hearing on that day at 10 a.m. My expectation at the status hearing is that the department will be able to inform me at that time regarding Ron Jones's prior conviction, and if there are any other issues in his past, based on what you, Ms. Jones, may share with the department, based on what you, Mr. Rial, may share with the department, and what the department finds out on its own through a background check, whether or not he is an appropriate safety resource. My intention is to place these children back in the home with the grandfather as a safety resource, as long as there are no red flags that come up and there are no additional issues that bring me concern. If there are issues, we will deal with those at the status hearing, but I want to give everyone an adequate opportunity to have those conversations and to do that background. In order to be able to do that, Ms. Jones, I've got to have you testing, okay?
Okay.
Because part of my responsibility is to make sure, again, that I place the children back in a safe and sober environment. Every time children are removed or re-exposed to potential drug use in the home, potential domestic violence in the home, we traumatize them and we make their life more difficult.
Yes, Judge.
Not saying that any of those things are going on. We're at the very early stages of this case, but in order for me to have that trust and that faith and place the children back, potentially with a safety resource, I do need to make sure that we can adequately address any issues you have. And I don't even know what those issues are yet because you've missed the last couple tests, okay?
Okay.
Okay. So, Mom, I need you testing before the next hearing. I need you to complete a chemical dependency evaluation. Mr. Peterson, will the department be using their art team to complete that?
As we could get it scheduled today, get her in by tomorrow if she's willing to go with the Rimrock Foundation and get her on testing right away through either CSI or Friedel.
Okay, Ms. Jones, I'd like for you to do that. If we can make that work, you'll be in touch with Ms. Eliezer after we get off of this Zoom hearing, and she will give you a time tomorrow as well as a location for your CD evaluation, all right?
All right, Judge. Thank you.
Okay, so Mom, I expect you to be testing. I expect you to have your chemical dependency evaluation completed. I expect you to have been in contact with your attorney to talk about this case and what the plan is. And I expect you to continue to participate with any of the recommendations that the department has. So one of the things I'm interested in is there's a company that we use here in Yellowstone County called Bear Family Ties, and they can do parenting time with you and maybe some redirection or some suggestion And so, Ms. Eliza, if you can add that to the list of potential referrals as you kind of look into the case, I'd appreciate it. Mr. Rial, I know that you've got some bigger fish to fry. You've got a warrant outstanding. Do you know who your criminal attorney is? Do you remember that person's name?
No, the attorney was court appointed, and I had that among the stuff as I kind of moved from friends' couches. So I don't know who that is. I don't even know. I didn't know that I had missed that hearing. So yeah, I want to take care of that. I just want my kids back, and I want them back in the home. And I don't know what I'm going to do, but I think you're probably going to tell me what I need to be doing.
I'm going to definitely give you my suggestions and try to get you on the right track so that we can keep this case moving forward. The most important thing you have to do right now, Mr. Rial, is you have to be in good contact with Mr. Reinsma. You two have made contact today. Mr. Reinsma has informed the court that you now have good contact information for him. So between now and the next status hearing, I need you to have a scheduled time for an appointment, whether it's over the phone, via video, or in person, depending upon limitations and restrictions, with Mr. Reinsma. Okay?
Yeah, I can do that.
Perfect. The other thing is I want you to understand why I typically don't like the drug patch. It's because the results are about 2 to 3 weeks delayed. So I may know 2 to 3 weeks from now if you were using, but I don't know right away. If you do UAs, I know right away, as does the department. And then we can keep moving this train forward without any question as to, let's get a CD eval, let's follow the recommendation. So for me, it's more of a timing thing. I'd like to have information sooner rather than later, especially when it comes to children. But I know that you said transportation can be a problem. Would you like to have the more, I guess, the speedier alternative, which is UAs, or would you like to do the drug patch where the information is a bit delayed to the court and the department?
Well, Your Honor, I'd like to be able to demonstrate that I'm clean. I think that would help me, kind of make my case that I'm safe to come back to the home. I'm just concerned about my ability to show up for the UAs. I know, and like my experience with that, if you're even late, you're considered as being positive. And so I'm concerned. Maybe, Your Honor, we could try the UAs, and if that gets to be an issue, I can, maybe talk to my attorney and we can take that up. But I'm just concerned about my ability to follow through with that, Your Honor. And I don't know what this business is of domestic violence. I don't understand that.
Sure. So there's an affidavit. You haven't seen it yet because you haven't been served. And in the affidavit, there's information regarding what brought law enforcement to your home in the first place. And then statements from other people about what your home situation may or may not have been like. Part of what I have to determine in moving forward with the case is on its face. So just the words on the page, are those sufficient for me to continue to move forward? Not saying that every fact in that document is true, simply that if I were to move forward as if it were true, that it's sufficient to justify what I'm doing. So what we're doing right now at this really, really early stage where people have not even really had an opportunity to meet with counsel, to talk about how these cases unfold, is to make sure that we hit as many of the areas where we may need some sort of services as possible. So one of the issues that is tangentially referenced in the document, so there's a reference to it, is that there may be an issue there. And so what we're doing right now is just making a list of all the possible things that could be on our treatment plans, on our individual lists of what we need to do, okay?
Yeah, sure. I mean, like I said, I'll do whatever I can to.
It's all the more reason, Mr. Rial, why you've got to meet with Mr. Reinsma to walk through the affidavit, so he can answer specific questions about the allegations and then what the timeframes are for moving forward. The other thing, and this is a to-do list for Mr. Reinsma, Mr. Reinsma, can you please reach out to the criminal side of your office and the public defenders, find out who Mr. Rial's criminal attorney is, and connect the two of them, please?
Yeah, sure, Honor. We'll do that right away.
Thank you. So Mr. Real, ideally, by the time I see you in about 2 weeks, I'd like your warrant taken care of. You'll have had a criminal attorney meeting, a meeting with Mr. Reinsma. You'll be testing, so we'll do a referral for UAs, and Ms. Eliezer is going to be the person that's going to be able to tell you where all these things are scheduled for. And then when we see each other in about 2 weeks at another hearing, we'll have a conversation about what's working and what's not working, okay?
Okay.
Are you willing to have a chemical dependency evaluation? Can we get that scheduled?
Sure. I mean, as long as I'm able to get there.
Okay, and again, the city bus is running like clockwork. They also have Wi-Fi in the bus. So you'll be able to, if you can get your phone powered on, you'll be able to make calls, check messages, and be on the internet via Wi-Fi while you're on the bus, okay?
Yes, Your Honor.
And Your Honor, I'm sorry to interrupt, but since my
Please.
client has outstanding criminal matters, I think he needs to consult with his criminal attorney before he agrees to do that CD evaluation. It may have some impact on that case.
Well, I'm going to disagree with you a little bit, Mr. Reinsma, because as a judge that also hears criminal cases, I can tell you that it is never a bad thing when I have a criminal defendant tell me that they are getting a chemical dependency evaluation to evaluate what maybe led to the criminal charge. But I'm going to defer to Mr. Reinsma, Mr. Real. And so what I want you to do is reach out to him. He's going to have information for you on that criminal attorney. But Ms. Eliezer, if we can maybe come up with an appointment for a CD eval in the next 3 to 4 days, that gives Mr. Real an opportunity to speak with his criminal attorney, with Mr. Reinsma, and still keep this case moving forward.
And when can I see my kids?
So my understanding is that Ms. Eliezer was, and I always say that wrong, Miss Eliezer? Is that better?
Eliezer, yes.
I always do it wrong, and you'd think I'd
It's all
figure
right.
out a name like Fair spelled F-E-H-R. But my understanding is you've already had a visit with the children at the department. Is that right, Mr. Real?
Yes.
Okay. Was another visit at the department scheduled at that time, or is there one set up in the future?
Not that I'm aware of.
All right. Is it possible to schedule Mr. Real for another visit in this week?
Yes, I will schedule one for tomorrow morning if that works for you.
I'll be there.
Okay. So I hope what you, Ms. Jones and Mr. Real, what you're figuring out is that the CPS worker assigned to your case holds the keys, right? Good communication, good contact with them is going to mean that your attorneys have good information. It's going to mean the court has good information, and it's going to mean that the guardian ad litem has good information. So remaining in good contact with her is going to be ideal. I think I've given Dad all of his to-do list before our next status hearing in 2 weeks. Department, from your perspective, I think it's also important, aside from all the referrals you're making for UAs, CD evaluations, I'd like Dad to have at least 2 or 3 visits a week until we kind of get this straightened out. So if the SRT can be available to facilitate that. I know that if we make a referral to one of the third-party agencies, it won't be picked up in time for our status hearing. Is that possible for him to get at least 2, hopefully 3 a week until our status hearing? He's had one this week. You got another one scheduled?
Yes, we will do our best to make sure that that happens.
Okay, great.
And Your Honor, excuse me for the interruption. Since we're looking at 13 days until the next status hearing, would the court be willing to order that CFS do the same for Ms. Jones in terms of visitation?
Absolutely. My expectation is that mom have just as much time with kids, and in the interim, I'd also request that grandfather be able to assist with parenting time for mom.
Thank you, Your Honor.
So I know we're trying to figure out if he's an appropriate placement in home or as a as placement for the children. But in the interim, based on the information shared today and the statements of counsel and the department, I do believe he's an appropriate person to help facilitate parenting time for mom between now and when we get to the status hearing, so that we're not constrained by the department's resources.
So Judge, we'll do as much of that as we can, keeping in mind that the kids are placed with this foster care and the transportation can be an issue at times, but mom could have as much visitation as is possible as long as grandpa's there until the status hearing.
Okay, absolutely. And if grandpa has a valid driver's license, a properly licensed and insured vehicle, and can provide copies of that to the department, then I think he can be an appropriate person to transport as well. So I do have to put those restraints on it, Ms. Jones, just to make sure. But the goal here is for you to see your kids as often as possible, again, in a safe and structured way, knowing that in 13 days, if everyone can complete the tasks I've given everyone, we're hopefully going to move this ball down the field, and we're going to be able to then find an alternative placement besides foster placement. Okay.
Thanks, Judge.
Okay. Anything that I've missed? Council, department, guardian ad litem, parents.
No, Your Honor.
Okay. Do either of you, either Ms. Jones or Mr. Rial, do you have any questions for me? Anything that I haven't addressed that you want me to address before we move on?
Nope, I'm just gonna contact Miss Eliezer to get my CD eval for tomorrow, and I'll go and get testing started again today.
Okay, so that's wonderful. Those are great. And then remember, you need to also reach out to your attorney and have an appointment set up with her before our next hearing, okay?
Thanks, Judge, will do.
Okay, Mr. Rial, any questions for me?
No, Your Honor, I'll talk with my attorney. I just want to get my kids back home with their mother, and hopefully get me back in that home as well too.
Okay, so for the time being, we're gonna have you stay out of the house though, until we get this figured out, and we'll move forward with that. Appreciate both parents' willingness to be here, to participate, to meet with your counsel, and to really be open to all of these suggestions. This all bodes really well for this process. So I look forward to seeing all of you in 13 days at our next hearing. Remember, 10 a.m. Your attorneys will get a Zoom link in advance of the hearing, and they'll be able to forward it to you so you can participate just like you did today. Okay?
Okay.
Okay. There's nothing further, then we'll be in recess on this matter.